all of you, members of the Petroleum Pipeline Subcommittee, as well as management and staff, not leaving aside the members of the public that are following us through the various live streaming platforms. Say to all of you, welcome to the Petroleum Pipeline Subcommittee meeting number 192, held on the 5th of February 2025, scheduled for the time of 9 a.m. to 12 midday. It's a virtual meeting held via Microsoft Teams. With me, I've got the members of the Petroleum Pipeline Subcommittee that I would just like them to greet all of us so that you can kind of calibrate their voices. I've got the Deputy Chairperson of NERSA, who's the Chairperson of the Human Resources and Remuneration Committee, as well as a member of this Petroleum Pipeline Subcommittee. Madam Mpungose.
Thank you, Chairperson. Good morning, Chair. Good morning, members. And I'd also like to greet members of the public who are streaming live in our proceedings. Thank you, Chair.
Thank you very much, Madam Zandile Mpungose. I will then go to Advocate Nomalanga Sithole, who is the CEO of NERSA, Chair of the Regulator Executive Committee, as well as a member of this Petroleum Pipeline Subcommittee. Madam CEO.
Thank you, Chairperson. Thank you, members and members of NERSA personnel, and all those members of the public that have joined us for this particular meeting. Good morning. Thanks.
Thank you, Advocate Sithole. I will then move on to Madam Nomfundo Maseti, who is the full-time regulator member, primarily responsible for pipe gas regulation. Is also currently assisting as the acting full-time regulator member, primarily responsible for electricity regulation. She's the chair of both the pipe gas subcommittee as well as the electricity regulation subcommittee. She is also a member of the Petroleum Pipeline Subcommittee. Over to you, Madam Maseti.
Good morning, Chairperson. Good morning, members, and good morning to the members of the public that are following today's proceedings. Thank you, Chair.
Thank you. I think we've got an apology from Madam Mr. Sibanda. We'll then proceed with the meeting. Members,
Chair, I'm in the meeting.
Oh, you're in the meeting. Oh, sorry. The apologies. We've got Mr. Fungai Sibanda, who is the part-time regulator member, who's chairing the IT governance committee. Is also a member of various committees. Also a member of this Petroleum Pipeline Subcommittee. Mr. Sibanda, over to you, sir.
Good morning, Chair, and good morning, colleagues, and good morning to members of the public. Thank you.
Thank you. I hope I'm done with all the members. We've got the team being led by Madam Xolile Mthwa, who's going to be responding to presenting the issues and responding to questions or comments by the members. Let's move on without much ado to the adoption of the agenda, which is item 3. Members, we've got the agenda presented before us with 4 substantive items. Just by show of hands, if you've got any changes that you want to suggest. I don't see any hands. By show of hands, if you support the adoption of this agenda for today. Thank you. Thank you, Madam Maseti, Advocate Sithole, Mr. Sibanda, Madam Mpungose. Thank you very much. The agenda is then adopted as is. And then we're moving to item 4, which is a declaration of interest. Any interest to declare verbally here? I know that there is none. And we'll then proceed and request you to please fill in the declaration of conflict of interest forms, declaration of interest forms, so that you may then share that with the Secretariat, Madam Patience Masonganye. We'll then proceed to deal with item 5, which concerns the final findings report on the monitoring of actual tariff charge by licenses in the period 1 July 2022 to 30 June 2023. Madam Chua, you've got your 3 minutes to present this item.
Thank you, Chair. Good morning, members, colleagues, and the members of the public. As Mr. Mkhize has indicated, the report that will be presented on the monitoring of actual tariff charge, I will request that Mr. Gaba assist in terms of introducing the report and just consider it as being read and focus on the silent issue. Thank you. Mr. Gaba.
Thank you, May. Thank you, Ian. This serves as a final findings report to a preliminary report that was noted by the PPS on the 2nd of October 2024. Just a little bit of a background. On July 2024, the NESA sent out letters to 12 licensees that charge tariffs to third parties in terms of paragraph 5.1 of the the letters requested the 12 licensees to submit information to NESA on the actual tariffs charged and volume stored to the third parties for the period 1st July 2022 to 30th of June 2023. After the review of the information submitted by the 12 licensees, NESA identified that 4 of the licenses, in the name of WASA, Transnet, OTMS, and VOPEC, were regarded to be non-compliant, however, on a preliminary basis with Section 21 and Section 28.6 of the Pipelines Act. On the 6th of November 2024, NESA sent out letters to these 4 licenses informing them of the preliminary findings and were given 30 days from receipt of the letters to respond to the preliminary findings. In terms of WASA, the preliminary finding was based on Section 21 of the Act, where it found that it was unduly differentiating between its customers. The legal principle contained, members, in terms of Section 21 of the Act, it requires that the licensees should not charge different tariffs to their customers or classes of customers unless the differentiation is based on objectively justifiable and identifiable grounds that have been approved by the energy regulator. So Table 1 of the submission clearly showed that WASA was charging different tariffs to different actual tariffs to its customers. And in response to the preliminary findings, WASA and NESA held various deliberations. And ultimately, WASA provided information indicating the basis on which it was charging its customers, which was based on the take-or-pay or pay-as-you-use basis. And furthermore, it provided distinguishing factors that influence the variations in tariffs to different customers, and that is contained in paragraph 6.2 of the submission. However, the differentiation factors that were provided by the licensee were considered to be very generic and do not adequately demonstrate the specific and identifiable grounds for each third party, which is what the energy regulator looks into or assesses when implementing Section 21 of the Act. And we had subsequent meetings in order to get that clarification from WASA, and to date we have not gotten the response or the adequate information that we had required from the licensee itself. And based on that, the preliminary finding, or the finding still stands. There's a non-compliant finding in terms of Section 21 of the Act. If VOPEC was also found to be compliant on the preliminary basis in terms of Section 21 as well, in its response, VOPEC had provided NESA with various information in terms of how it differentiated between its customers, as contained in 6.5.6 of the submission. And in addition, VOPEC had provided how it applies these distinguishing features to each and every one of its customers and the different circumstances that led to the varying actual tariffs. And that is contained in 6.61, 6.62, and 6.63 of the submission. And therefore, the energy regulator had found it adequate to be compliant with Section 21 of the Act. In terms of OTMS, which was also found to be non-compliant with Section 21 of the Act, as demonstrable in Table 3 of the application, in terms of its response, it was quite the same as WASA, in that it also supplied the energy regulator with the generic distinguishing features that it uses when negotiating actual tariffs with its customers. However, it has also failed to demonstrate how it applies these differentiating features to each and every one of its customers. And therefore, the finding still stands, particularly for OTMS. In terms of Transnet, the fourth licensee, we find that it had been non-compliant on a preliminary basis, of course, and that it failed to comply with Section 28.2 of the Act, in that it charged its customers tariffs that exceeded those that were approved by the energy regulator for the first 9 months of the audited period. However, in a meeting that was held with Transnet technical team, it became evident that in providing the information to the energy regulator, there were errors that were noted, or that happened in the information that were contained in the information that was submitted to the energy regulator, and that in a figure that was supposed to be 50 cents per liter was recorded as 12.05 cents per liter rather, and that was an error in their own, which they later on proved by providing various information through the subsystem as well. And that we were satisfied of the response from Transnet, and therefore found them to be compliant with Section 28.2 of the Act. The recommendation, members, is that we would like for members to approve the final findings report for the monitoring of the actual tariffs charged to licensees for the period of 1st July 2022 to June 2023, and also differentiation features that were provided by VOPEC as stated in paragraph 6.61 and 6.62, 6.63. Thank you very much.
Thanks, Mr. Kaba. I hope that in the stakeholder engagement, you'll also try to be proactive around this matter, so that you just ensure that all the licensees and prospective licensees are informed of such requirements in terms of the Act. Members, do you have any questions, comments, or guidance to give to the team? Madam Pungose?
Thank you, Chairperson. Thanks, Ms. Mtwa and Mr. Kaba, for the presentation. I just have one question, really. It's a question of clarity on clause 4.7. Page 4 of 18. I just want to find out why is there appears to be no consistency in how we process these reports. I saw that it's actually 4.6 and 4.7. Since we started, some reports were noted and approved. However, the one of, I think, July 2022 to 30 June 2023, it appears as though it was only noted by PPS on the 2nd of October 2024. So I'm trying to clarify, why was that one in particular not approved? Because all the other reports since this process started have been noted and approved, the final findings. That's all from me. Thanks, Chairperson.
Thank you, Madam Pungose. Madam Maseti.
Thank you, Chairperson. Chairperson, I just want to start off with the with our mandate in monitoring a differentiation that is undue or unduly implemented by the licenses, and that really has to do with the empowering provisions that we used to evaluate this application. That is Section 21 of the Petroleum Pipelines. As we will all note there, that obviously the phrasing of that provision is slightly different from the other sector-specific legislation here at NERSA. For instance, in the Gas Act, they will state clearly when we talk about objectively identifiable differences, which will have to do load factors and all of that, or interruptible supply, duration of the contract, access, the transmission distance, and things like that. So they will state clearly the categorization of the ones that are objective factors. And then they also provide a catch-all aspects that may be pertinent to the industry, but they don't list those. So in the petroleum pipelines, it doesn't necessarily state what are the specific factors that are viewed as objective and identifiable differences. So I wanted to understand then, from our assessment, what factors did we consider to come to the conclusion or findings that will support evidence that there is a discrimination or undue discrimination, rather than simply looking at the differences in tariffs that are charged or levied, but just to understand the underlying factors so that the team can then be in a position to assess those factors that were used in those circumstances of charging different prices between different customers. So that is the most important thing, because that differentiation or discrimination is done at the level of customers. Now, it's important for us to look at these customers. First of all, where are they located? And also just look at the equivalent transactions. With that, I mean at least sort of the size of or the amount that they're purchasing. The time of purchasing, because discrimination can be discrimination over time, the time that they're purchasing these things. So I'm just looking at the location, looking at the size of the purchases, whether they're equivalent, such that indeed this is a differentiation that we will be worried about, because it will disadvantage somebody else, because what is embedded in the discrimination is the issue of fairness and equity. So if we're not able as a regulator to articulate those things in the simplest way, so that we apply that rationality of looking at whether this was really something that was bad and unduly, but without stating the factors properly, that for me, it becomes a bit of a challenge in terms of the problem that we are trying to deal with. And secondly, I just wanted to check whether we have pre-approved factors or identifiable differences that we can use, so that there can be predictability on the licensees in the industry as to what is it that the regulator is likely not to approve or authorize if we're to do this, because we need to be transparent and we need to make sure that we provide predictability. Now, also so that when we approve these tariffs, then it will mean that at that stage, we must also approve what that licensee will then use for it to implement the tariff. Otherwise, how else is it supposed to implement the tariff and make sure that there will be some, competitiveness and also bargaining from the viewpoint of customers who may actually approach the licensee, wants to buy something and bargain for a better price, for a good price. And at least that licensee needs to know what are the parameters of allowing bargaining and allowing discounts. Otherwise, if it's just a blanket thing, then it becomes a problem when we might not be helpful to the licensee. So the second thing is that issue of the approval. Whether we do the approval at the stage of maybe the tariff applications or asking the licensees on what factors they're going to use in the implementation of the tariff so that they can be able to grant discounts, so that they can be able to accommodate bargaining from customers. Or if then we want to look into it as a blanket factors that all the licensees in the industry could consider when they charge charge their customers. So that is the second thing. And then, Chairperson, with regards to the impact, I think that becomes also important because we want to be very clear in terms of the value add of our intervention, so that it is not a question of just saying, well, we just see these price differences here, and therefore just the mere fact that there are price differences, we think that there's something wrong or we condemn that. Price discrimination is not a per se. It is not a per se violation. It is a rule of reason. So we have to apply rationality. Hence, even in that empowering provision, it says, unless on the basis of identifiable differences or objectively identifiable differences, that shows the principle of a rule of reason, that there might well be reasons why different prices had to be charged, and therefore also maybe also the impact. So I really wanted to check, therefore, the impact on this. Lastly, Chair, I would like to understand whether we do take into account in the consideration of the undue or the alleged undue price discrimination, whether we do take into account structural issues in the market between these customers that are being treated unfairly or treated differently from each other. What is it that is of a concern? Is it that the one that has been made to pay a slightly higher price is impeded from expanding in the market? Or is it impeded in some ways from doing something that will make it competitive? What exactly is the rationale for us to really condemn? Is it on that basis? Also, when we look at the factors that were used, or is it a structural issue that we want to condemn this undue price discrimination because we believe that other people might not even be able to enter into the market, or others will be forced to come out because the price is higher and therefore it disadvantages the other? I think those are the critical economic reasoning. And that is why we also have the issue of the regulator looking at it not as just as a per se, just looking at the differences in price or tariffs, but to apply reasoning in terms of looking at the factors that were considered at the time of charging those different tariffs. Thank you, Chairperson.
Thank you. Over to you. Thank you very much, Mr. Massetti. Over to you, Mr. Sibanda.
Thank you, Chair, and thank you to the team. Chair, mine is around how we've interpreted the applicable section of the Act here. That is Section 21. And whether we've not applied a standard that's not intended by the Act. So if you look at Section 21, it says licenses may not discriminate between customers or classes of customers regarding access, blah, 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 except for objectively justifiable and identifiable grounds approved by the authority. Now, when I looked at WASA and compared their response to OTMS and VOPEC, what I could deduce is that WASA probably did not indicate that we charged customer A this much because of 1, 2, 3. However, they did list the factors that they considered, and also gave an example to say we considered, for instance, infrastructure investment, such as those of Engen, for instance. Now, in our reasoning on paragraph 6.3, we say the differentiation factors provided by WASA are generic and do not adequately demonstrate specific or identifiable grounds applicable to each third party. And it seems to me that what we are looking for are factors that are specific, but that's not what the Act requires of us. The Act has not said that we must apply factors that are specific. It only talks of identifiable, objectively identifiable, and justifiable. So in other words, they must be able to justify, or they must be able to identify and justify those factors with the grounds. But it seems to me that we have added a requirement that says be specific and tell us the reasons for each and every customer that you have. Because if I look at their factors, I could not find a difference with those of TMS and VOPEC, which we have accepted. So I was a bit unclear, and the question that I have is whether the licensees themselves do understand what we are looking for, and are the factors, or is the approach, not necessarily the factors, but the approach that we are looking for, is that what the Act requires? Because I think WASA has given us factors, but we are saying they are not specific. I'm saying, but those factors seem to me are the same factors that OTMS and VOPEC have also given us, with the exception that the other two went a step further to say with customer A, customer B, and customer C, this is what we did. So I'm not too sure whether we're not imposing a higher standard here that is not intended by the legislation. Thank you, Chair.
Thank you very much, Mr. Sibanda. EM and the team, may you please respond?
Thank you, Chair. I will allow Mr. Kaba to come in first, and then the HOD. Thank you.
Thank you, Chair. In terms of Ms. Fungose's question regarding what has changed maybe in this, ma'am, I think in previous reports there had been a change in interpretation, if I may put it that way, in terms of the preliminary or the final findings factors, or noting or approval thereof. Because in the previous reports, there were, let me say, there were decisions to issue the preliminary findings as sort of final, and not necessarily came back to challenges down the line with licensees, in that they felt that they were not given the chance to respond to the findings by the energy regulator. Hence, now the approach would be, based on the information that they had submitted, and then.
I think, please, if you can just be very brief and to the point. There is issue that Madam Ponce had raised, is one on paragraph 4.7, where you've got noted and approved one report, and then the other one was approved, was noted only, to say why. If you read to 4.7, you can, if you have not applied your mind on it, maybe someone else can come in whilst you are going on to respond to others, because it's a specific issue. Madam Bogo?
Thank you, Chair. Just to be specific to this one, I think the difference between the previous reports, especially the final reports, and this one, is that the preliminary findings that were made in the last installments were then answered away by licensees, and therefore the final reports did not have final findings. But then this one, okay, well, the difference is that some of the reports did not have final findings, and the other reports actually do have final findings. So we need noting of the report and approval of the final findings. So that is the difference, Chair. I hope that is clear.
Okay. Rempungo, are covered?
Chair, then I'll take it that the report that was noted in October last year only had preliminary findings, hence there was no need to approve those.
Yes.
But just to note.
Okay.
So will there still be another report coming after that, or is this the one, the fifth one that we're dealing with now?
This is the one, ma'am, that we're dealing with now.
Okay, Chairperson.
Thank you.
All right, thank you.
All right. May I proceed then and respond?
Thank you, Chair. In terms of Ms. Masethu's questions, I will try my best to try and answer all your questions adequately, ma'am. You are correct in terms of the interpretation or the wording of Section 21 of the Act, in that it is quite different if you look at maybe Section 22 of the Gas Act, in a way it prescribes maybe some of the factors that may be applied or regarded as justifiable. However, in our endeavors, we did try and have deliberations with most licensees in the industry to try and get a feel or a information on what typical grounds are used when negotiating these actual tariffs with third parties. And we found that, I don't know if it's appropriate to have let's say we find justifiable, or we compiled justifiable grounds that are used by a majority of the licensees, even the big ones, as a guideline on what factors are considered when the licensees are negotiating actual tariffs with the customers, such as your total capacity, throughput, the additional services, after hours services, length of contract, the timing of negotiations, as well as capacity or the product profile itself. And we try to use that as a guideline in terms of determining what the justifiable differentiation factors are used, particularly in the industry itself. And also, we try to assess maybe what we mean by saying that it is justifiable, in that we try to look at factors that are applicable for each and every licensee, and then if one customer actually has a specific actual tariff that they negotiated, then another customer that may come with the same set of circumstances will get pretty much the same actual tariff, which is what we generally endeavor to use as an assessment tool when assessing the justifiability of the actual tariffs or implementing Section 21 of the Act itself. In terms of approved factors, as I mentioned, we don't have particularly approved. We do have these factors that we use as a guideline. And in terms of the impact, ma'am, the monitoring of these tariffs has allowed us to narrow down on some of the behaviors, for lack of a better word, by licensees applying the approved tariffs by NERSA. I think maybe colleagues can come in terms of the economical aspect of it, in terms of the impact, ma'am. Maybe I can stop it right there and allow some of the colleagues to help out.
Yes, Madam Bogo. I think, Madam Bogo, if you can just go straight to the point here, please, because the other thing is that if you look, for example, at Regulation 3, which for regulation made under the Petroleum Pipelines Act 6 of 2003, is that in the granting of that access to capacity, storage capacity, or pipeline capacity for third parties, is that one of the things that it should not discriminate on any ground as contemplated in Section 21 of the Act. That part, in fact, then it says it becomes a way of excluding other parties by way of charging them a higher tariff than the others. Because when we started off in the beginning, we're not tracking this. We're setting the tariff or approving the tariffs, and then we let the industry then ensure that they comply below that. Now we're moving even further to check what is actually being charged, so that we can be able to look at also the relevance of what we're setting as NERSA. And then from that point of view, is that there is a commercial harm to the person that is unfairly discriminated. But what we cannot take away is a need by way of maybe frequently asked questions, whatever, for us to look at putting these conditions up front, these justifiable and identifiable grounds upfront, so that we help the industry players or prospective industry players to understand what we charge. But definitely, when one is they want to preclude you from using a facility, they will then charge you a higher tariff as compared to the other, particularly where one looks at the issues of the need to transform this sector, the need to ensure that the new entrants are not barred from entering and playing this sector. Over to you, Madam Bo.
Thank you very much, Chairperson. I think your response also helps in clarifying some of the concerns from members. So maybe to also talk to Ms. Maseti's questions, especially that one of predictability. So because our Act does not clearly state the factors, we have also considered having or drafting guidelines and publishing guidelines on these differentiation features that are generally acceptable to the regulator. But then you'll note that we recently started this audit exercise. So we wanted to collect enough data. And then we still are to have our planning session as a division. But then this is also something on the cards that we develop guidelines and consult on them, and then publish the guidelines that provides this issue of predictability. And the last of Ms. Maseti's questions is with regards to us having then considered structural issues such as market foreclosure. I think we are not there yet, because you know that the licenses considered still non-compliant in this case still have not provided us with the required information. But then once we have that information, we'll be able then to look at the issues of impact and if there's any non-competitive or uncompetitive practices happening there. So the next installment should also talk to that, Chairperson. And in answering Mr. Sbanda's question with regards to our mandate in terms of the Act and whether or not we are extending our mandate. So, Chair, the Act requires that licenses that are to differentiate in the implementation of tariffs get those differentiation factors approved before implementation. The anomaly here is that the licenses were found to have differentiated during the audit. So that has then required, like we are also required in terms of the Act to monitor this implementation and make sure that there is no unfair discrimination. So for us, we felt like if we're just looking at the generic principles, then we are not achieving the mandate of checking. So for instance, if a licensee says they were different, it's based on contractual arrangements or the length of contract. So for us, if we have not sent those contracts or there is no information talking to how long is the contract for customer A, how long is the contract for customer B, then we have not verified the fairness element of that implementation of the tariff and the differentiation. So that was the thinking from our end, Chair. We will be guided by members. Thank you.
Right, I note your response, Madam Bogo, but I think it's important to especially on the last issue that was raised by Mr. Sbanda, to say that to rephrase and say they did not specifically address how these grounds apply to their customers. Because if you are talking specific, it's like you're introducing a new term to say that the grounds must be specific, you know. But whereas here it just says justifiable and identifiable. But then if you are saying you are using, for example, volume to discriminate or term of contract. You then must be specific to say so and so is on 3-year term, this other one is on 5-year term, hence the difference. It is that specific in that regard, and not to put it as if you are introducing a new term that is not in the Act. So please just rephrase that specific issue or just qualify it more so that it does not seem to be introducing a new condition. Madam Massetti.
Thank you, Chairperson. Chairperson, we did not. I'm still of the view that in terms of what the Act requires us to do, if we were to find a case of undue discrimination, we must be very clear in terms of the evidence that is deduced to support that finding, and make an assessment that will really demonstrate what is the discrimination here, the specific discrimination, and why what the licensees have stated, the reasons advanced by the licensees as the reasons that they have used, why are those reasons not acceptable? Especially because the law did not prescribe the specific factors. And here, there are no guidelines. I'm not aware. I mean, if the team can, point me to the guidelines and attach them. The guidelines where the licensee ought to have known these factors upfront, so that you can't then come and say you are wrong when the licensees say, oh, when I'm doing my business, I looked at these customers, and for this customer, I simply used this. There was nothing that the energy regulator has pointed out to me to say, I cannot use these grounds for me to apply discounts and maybe a better discount when somebody comes and negotiate for a better price. Price discrimination or differentiation is really meant to actually allow the bargaining on price. And that bargaining, our duty as a regulator is not to prevent the bargaining. Price discrimination happens every day in our lives, and there is nothing wrong with it. It is only wrong under certain circumstances. Hence, I mentioned that for a regulator anywhere in the world, the rationality that must be applied by the regulator is the rule of reason. And that rule of reason would have failed because we did not put up front to say what are the things that are permissible, what are the things that are not permissible. And when the licensees come and say, here are my reasons, on what grounds are we saying these reasons will still disadvantage or impede someone from doing this? We're unable to provide that kind of evidence so that we can then say that they're not acceptable to us. And that is also the point that Mr. Simanda is making here. And if from our side, even from legal minds, legally trained people, they must be able to ascertain the sufficiency of evidence that is presented here, which will assist us in making the right decision as to whether or not, when you apply the analysis here, indeed, there is no other explanation that can be acceptable that must be allowed by the regulator. And therefore, on these grounds, they fail. I don't think that we are there, Chairperson. Thank you.
Thank you very much. I think what must just be clear here is that there is the objects of the Act provided broadly, the outline. And then you've got Section 21, which then says that the conditions or service that is being the way discrimination applies when it comes to access, the tariffs. It should not discriminate except for objectively justifiable and identifiable grounds approved by the authority. So the applicant or the licensee should get the approval from the authority, which in this case is the energy regulator. Having not secured that, the regulator now does the investigation or the auditing and finds that there is this challenge. If you're talking of the rule of reason, it will still be applicable here because I'm looking at it from the point of view that you have a tariff and then people are supposed to charge this, and without unfair discrimination that does not comply with Section 21. Now, when you've got that, you get a licensee who says, these are the grounds I use, but the licensee is not providing how customer A has actually been charged more than customer B, but laid out the principles. The principles, the guidelines will assist the licensees, which we all agree on. And I think that they should be there, whether they will make them in form of guidelines as guidelines or if it is frequently asked questions. But for me, guidelines make it even more, helpful, like we do with prudence. But what is imprudent and not prudent can be tested at the time of coming to it. And people in the industry, they understand what is imprudent and not prudent, or should understand. And the argument will be, when something is presented, is it like that or not? When it comes to discrimination, it is known that there are volume discounts, for example. You will have that. You will have issues of the cost of serving that particular customer playing a role. That will then be engaged upon then. The issue is the team saying that in this instance, the person says, I use volume, I use contractual terms, but without providing a reason why you have A and B being charged differently, which then is the case here, like in the case of WASA. So in terms of the team having not looked at this from a point of view of saying that there are no grounds, I think here we need to get clarity, because it is confusing in terms of what you are stating now. Because the fact that there are no guidelines, they are not put up front, does not preclude the team from assessing them, as far as I can see it. So I would like to give Mrs. Banda and Madam Pungose, and then if we may please just move towards wrapping up. Thank you.
Thank you, Chair. Chair, I think from my side, maybe I just need some comfort that what we are looking for in the specific case of WASA, but maybe applies to all licenses, is quite clear. Because I think sometimes we may use technical language that probably is not clear to licenses. So I just needed that comfort that WASA is aware of what we are looking for, or at least we've clarified that. Perhaps to use the example that was used by Ms. Boko, if he talks of the duration of contracts as indicated on page 7, did we indicate that, can you please supply us with those contracts? So so for me, I think it's just that comfort, so that we can move forward. So the other thing in terms of process, because now we've made final findings here, and that's what we are being requested to approve. But it seems we also are giving the licensees a chance to submit further information, and then we say that once we have assessed that then the findings will be communicated. It's a bit confusing to me, just in terms of the process here. If we are making a final finding, but yet we are still requiring licenses to submit further information, and we are saying we'll assess and then make findings and communicate those upon completion of the assessment, paragraph 6.4, and I think elsewhere as well. Maybe if I can be clarified on that as well, Chair. Thank you.
Thank you very much, Mr. Sibanda. Over to you, Madam Bongosa.
Thank you, Chairperson. I'm partly covered by Mr. Sibanda. I was going to suggest that, going forward, when we afford, licensees that 30 days to submit further information, I think it is necessary going forward that we tell them specifically the information that we require. If we want detailed information on how they decided to charge a particular tariff for each third party who's their customer, then we tell them that exactly, because the reasons that they've given, they seem, at face value, quite reasonable. To say, if someone has got a long-term contract, for instance, at least you are guaranteed your income stream, and hence you can negotiate a better tariff for them compared to someone who's got a short-term contract. And also someone who requires additional infrastructure. Obviously, their tariff will differ to someone who requires less. So those are things that they've given without giving, to say for this particular customer, these were the considerations. For this one, these were the considerations. So if that's what we require, then let's make it very clear, because our findings, our final findings might be incorrect based on the fact that they gave us high-level information because they did not realize that we wanted detailed information per customer. Yeah, thank you very much, Chair.
Thank you very much. Madam Bogo, will you respond?
Okay, thanks, Chair.
Just hold on there. I think Madam Pungo said you still wanted to say something?
No. It was a legacy hand, Chairperson. Sorry.
Thank you. All right, Madam Bogo.
Okay, thank you, Chair. Mr. Sibanda's follow-up questions. Yes, we have clarified the requirement and we have been specific now to the licenses, because following their submission of information, we then responded and had meetings with them. They're now very clear in terms of the information we require. So in terms of the process, the problem now that stands, especially for OTMS and WASA, is that we do not have all the information that we require. And they have not been forthcoming with the information, even after the meetings we've held with them. So the finding now is that the finding therefore stands, and then which then allows us to now use the compliance procedure in terms of getting the information that we require, so that we may also look at the issues of impact and assess if there are any constructive market foreclosures that are happening should the findings stand even after we have gotten the information we require in terms of how the principles have been implemented to get to different tariffs. So we're saying that the findings stand, and we're going to enforce the submission of the information by the licenses that we require. But then without a final finding to say there is non-compliance, we can't then move to the compliance enforcement procedure. Thanks.
Thank you. Just want to check if we have collaborated that with Mr. Mbetsi from LAS, because now it's like they have not provided the information that they were supposed to submit to us, and therefore there's a decision that the non-compliance is deemed to prevail still in terms of your finding. Just want to your voice there, Mr. Mbetsi, in terms of the legal soundness of the stance.
Thank you, Chairperson. Chairperson, the legal soundness of the decision will only come out when it gets to be challenged, Chairperson. But here as we are right now, and we decide that we are not going to approve this because of the non-availability of the justifiable decisions, it can sound okay for us up until the day when we challenged to produce the justifiable grounds, which we are not going to produce. But be that as it may, Chairperson, the justifiable decision, the justifiable grounds could even be found in other legislation, like the Constitution. The Constitution has the justifiable decisions grounds when it comes to unfair discrimination. And if you check your section 9 of the Constitution, Chairperson, it elaborates very well in terms of the discrimination should be unfair in order to stand the rule of the law, which means it's not really outright prohibited. You will recall, Chairperson, on the case of Transnet and Sosol, there was an issue that was relevant to discrimination, but then the court reiterated that it was not really a discrimination. It was a differentiation, and that came after the issue of discrimination was raised as a defense. So even perhaps that process can be followed with regard to the NESA in case we're going to be challenged based on the decision that we've taken regarding the discrimination. Thank you,
Mr. Mbezi, let's just cut to the chase here, please. The simple question is this. You're talking of a final finding whilst you are waiting for information from the licensee. And the question is, should that be the case, that you say, I've come to a final conclusion that this non-compliance prevails? That is the question.
Chairperson, I do hear the question, Chairperson. The issue is if you were to take a decision on the contrary, and then tomorrow you decide, you realize that the decision that you've taken is not right, you're going to have problems returning back for that decision. Because as far as we're concerned right now, Chairperson, we don't really have enough ground to decide on that issue, like what Madam Mercedes said. We do not have the benchmark to look at it to see there's 1, 2, 3 that's not justifiable. Remember, the justification here is not only justifiable, Chairperson, it is objectively justifiable, and that means something in terms of the law.
Okay. Members, this is the feedback, and therefore, what is your recommendation, Mr. Mbezi, in this case where information is still outstanding? And in other words, to say that, because there are two ways of looking at it. Maybe to say, one, you are not you have not provided us information. You are supposed to submit this information in terms of section so and so of the Act, and therefore here is a non-compliance with regard to you withholding information, right? And this hangs. Or you've got a situation where you say that the finding, as we had in the beginning, still stands because you have not provided us this information that we need, because it's about the provision of the information now. Which way do we go? Your recommendation?
My recommendation, Chairperson, is we need to have all the available information in front of us. That way it will be fair for the energy regulator and it will be fair to the licensee. Because, Chairperson, if you look at this, like Ms. Nowe said, it's not more like to put the cart before the horses, Chairperson. You don't discriminate and then we approve or we disapprove later. That wouldn't work, Chairperson. They say in the approved justifiable objectives, approved, it means that should be done before the implementation.
Okay, no, it's fine. I think, members, from what I'm getting here, is that we should return this for information to be provided prior to the conclusion of this submission. There are other sections of the Act that could be invoked with regarding non-compliance on the part of the licensees involved regarding the provision of that information. And those must then be dealt with by the division. Are we supportive of that recommendation?
Chairperson,
Yeah.
just to check, are there not timelines to this submission in terms of statutory compliance, Chair?
Okay, I see Madam Nomfundo Maseti's hand, and then I'll go to you, Madam Twa, in response to what Mrs. Kwan has raised. Madam Maseti?
Thank you, Chairperson. Chairperson, I support that the report is just not ready for a decision. Otherwise, there will be risk. And then the other thing, Chairperson, that I would like us to make sure that we do right, we can in a governance session, not even today, if we don't have that time, talk about some of the things that must be given consideration as the team will be working on getting the relevant information, also ensuring that the processes are sequential. We can learn from how these things were done in other divisions, because we also have senior counsel advices on how we give effect, even to consider the proposed maybe identifiable differences together with the tariff that is applied for. Same with the maximum prices. We have done the same thing, and we have implemented it since 2014 in the way that we've advised. So I think there's a lot that we can learn from procedural processes and also to cover the energy regulator, but we can discuss those in a governance session, Chairperson, just to learn from each other what other divisions are doing and where they were tested on some of these matters in the courts, SCA, as well as also in the High Court. And those things, the way that we advised, they were never challenged procedurally. So we must not reinvent the wheel. Thank you, Chair.
Thank you. Madam Twa?
Thanks, Chair. I think maybe we'll take the guidance that has been given. However, I think the concern was that there was a report that the licensee hasn't been forthcoming. Hence, we had to make a decision to finalize this on the basis that they've been given sufficient time and we have had meetings with them, but we haven't been receiving the information. However, to respond directly to the question by Mr. Sibanda, it's not an APP target. However, it is in the contracts that annually we need to do this audit and finalize them before the financial year end. Hence, we have to set timelines for the licensee to respond in the letters and also afford them the meetings and all that. Hence, we got to this point that we respond because we haven't had any a response from them. Thank you, Chair.
Thank you. I think then we take it back. We'll discuss further in the closed meeting, the governance meeting, regarding how to proceed on these matters and how to streamline them, including the fact that when we're dealing with these matters, LAS is part and parcel of the team. We shouldn't be coming here and having to ask for a legal opinion. All of that comes together, technical, legal, engineering, all of that, all come together. So in future, let's make sure that we work in that fashion that is very cooperative. All right, we move on this one. By show of hands, members, if you support that this be taken, be returned for enhancement based on the information that's going to be coming forward from the licenses, by show of hands. God, Madam Maseti, Advocate Tole, Madam Pumose, Mr. Sibanda. I also support that. Thank you. Take us through then to the second presentation, Madam Twa, on the Sunrise Energy Prudency Assessment report.
Thank you, Chair. And before us is the report on the Sunrise Energy Prudence Assessment that has been conducted. And Mr. Ndlovu will present the summary and highlight salient issues for members to consider. Thank you, Mr. Ndlovu.
Thank you, EM, and good morning, members and colleagues. This is a decision and reasons for decision document for Sunrise Energy's Prudence Assessment Report. Taking the submission as read, I would bring to the members' attention the process followed and the basis in undertaking the Prudence Assessment. Chair, we received a report by our consultant which was tabled at the PPS of March 2023, and the report was shared with Sunrise Energy. Sunrise Energy was due to prove the prudency of the costs on the findings by the consultant. Additional information has since been shared by Sunrise post the consultant's report, and the NELSA technical team went through the additional information as the consultant's contract with NELSA had ended. And then, Chair, further engagements were undertaken with Sunrise on the additional information provided. The decision attached as Appendix A should be read together with Annexure 1, which is a consultant's report, as the decision does not replace the consultant's report, but mainly talks to the further analysis of the additional information received and the overall analysis and findings thereof of the imprudent amount provided on page 6 of 76 and page 29 of 76. Chair, it's also worth noting the confidentiality aspects of the report, as the report talks mainly to the Sunrise contractual agreements with its contractors. It is hereby recommended that the PPS approves the final prudency assessment report attached as Annexure A, which goes together with the consultant's report attached hereto as Annexure 1. Thank you, Chair.
Thank you, Mr. Ndlovu. Any questions, comments, guidance from members? By show of hands. Mr. Sibanda?
Thank you, Chair. Chairperson, just a general comment really around the process here and the time it has taken us to finalize the prudency assessment. I suppose there are lessons to be learned here. But what I wanted to find out, because there's an indication, or rather, sort of a proposal that the team needs to undergo training to be able to conduct prudency assessment. So my question really is whether we have a clear plan around this, and perhaps if there are timelines as well around that. But I think it's a good thing that we need to create capacity internally. Otherwise, I support the recommendation. Thank you, Chair.
Thank you, Mr. Sibanda. Madam Massetti, over to you, ma'am.
Thank you, Chairperson, for the opportunity. Chairperson, just on the issue of the timing. Yes, this is also in terms of the process. Just on the issue of the timing of the initiation of our prudency assessment or inquiry here. I just want to check whether it was initiated at the completion or after the completion of the construction activity which we licensed. I think that becomes important also during the construction time, because the money has been spent, and also it's important that we apply ourselves properly there. So I just wanted to check the timing of the initiation of prudency, because the licensee has come to us in terms of the infrastructure that they need. But also in addition to that, you will recall that this licensee came back to make technical changes from the original plan for its project. And there was an issue there with regards to those technical changes, which then resulted in a significant or substantial financial implications. I think also from the perspective of a third party that would like to connect to the to the infrastructure of this licensee, and also this licensee having to spend because it needed to amend the original plan. So there is also that aspect of capital that was spent because there was a need to make changes in the scope of the project or in the way that the project or the infrastructure was supposed to be laid out. So I was wondering if the prudence assessment looked into that part of the capital that had to be spent after the license was granted, and therefore because of that technical change in the layout of the infrastructure and additional things, then the licensee came back to NERSA for an amendment of license because of that significant change, which also necessitated the amendment of the license. I would like to check then the capital associated with that change, whether that capital spent was also looked into in terms of the prudency assessment. I have not particularly saw that. Maybe it was the way that I have read the document, but I thought through this clarification, the team will understand exactly what I am trying to ascertain here. That's all, Chairperson. Those are the two questions on the timing, as well as on the capital associated with the technical changes that were done after the license was granted. Thank you, Chair.
Thank you. May you please respond?
Thanks, Chair. Maybe if I may start. In terms of the skills required for the process, initially the first two assessments were done with the consultant, and we were able to do some skills transfer. However, due to sort of diminishing a budget for this, which was supposed to be a 5-year project with 5 assessment, then we decided to do it internally with the skills that have been gained. We do have a plan in terms of attending courses for colleagues. And we would like that each and every colleague is able to participate in this assessment. Hence, we've looked at training such as contract costing, and Mr. Flujana is responsible for our capacity building in the division and is looking at that. The timelines we may not have them set, but every year we do try that we get some of the colleagues to attend such training, which will assist us with our upskilling on improving in terms of this assessment. So there is that plan, but maybe after our meeting in our planning meeting in Feb, then we can sort of see how far we've gone and how many colleagues still need such training, and maybe we can provide them timelines in the next meeting. In terms of the timing, that's some of the lessons that have been learned. I think because we have recently started in terms of doing this assessment, and I think we in the next PPS will present our 4th report. We have as part of the learnings that we need to try and do this assessment as early as possible after the construction, or also maybe prior in terms of looking at, because we do have the guidelines, and just working with the licensees to ensure that they are aware the guidelines and ensuring that they avoid any imprudent activities. And then we also then work immediately after the construction has been done to then start with the assessment. I would allow other colleagues who are in the team for the assessment, prudent assessment, to then come in to add on the question that have been raised by Ms. Massetti. Thank you.
May you please move quickly, Mr. Martin?
Morning, Chair and members. Valid question, Ms. Massetti, the timing. We have to just double check the facts, but what you are correct that it was the technical change. The exact timing in my recollection, which I need to confirm, was that resulted actually in a re-advertising of the application to include it, and it was issued with the MBM. There was subsequent amendments which affected the storage side. So there's two aspects. In terms of the loading, in my recollection, it was dealt with prior to the decision, but obviously you're correct, it could have had cost implications. The storage part was done part of the amendment, which was post the licensing, so that effect may be different. But the actual timing, it's at this point it's difficult for me to say, but that's my recollection at just from going back many years.
Okay.
But it could surely have had impact on that. But the way the contracts was crafted, I think, was already for the infrastructure that was there. So sorry, Chair.
Okay, no, thank you. I think I see a thumbs up that the metals are being raised. I take it that when it comes to the capacity building around being able to conduct these prudency reviews, is that the division is part of the plan of the division, also having been raised as to include it in the panel, for service providers for NERSA, to make it easier that when one needs a specific skill, to be able to source it from outside. So it's a combination of enabling speed of acquisition of specific skills, as well as the training of people internally. You note that it also comes at the back of the Transnet prudence assessment, which assisted the team to acquire certain skills, as well as also just for us, even for the leadership of the division, to have better insights in terms of how these need to be conducted. They've taken longer because of it having to be done in-house. I must also say that when it comes to the timing, because you can do ex post or ex ante in terms of our guidelines, this is ex post, including all the changes that had come, because it comes way after the implementation or the installation of the infrastructure, when the facility is fully operational, and all needed to be and include all the CapEx, whether there were changes while the project is on the go, which is also understood in terms of whenever you're developing a project, there would be scope changes from time to time, depending on the nature of the project. So all of that is considered. But at the same time, I think it's also incumbent upon me to also say that we are grateful for Sunrise Energy in terms of I think there's a change in terms of being responsive and very much attentive to what the regulator requires, despite the challenges that they face due to staff turnover, which made it sometimes difficult for them to supply information on time. With understanding what staff turnover results into. but they've done their best and they are very cooperative when it comes to such matters. Thank you. I see you're here. I've got a hand up from you, Madam Maseti.
Thank you, Chairperson. Thank you for clarity. Yes, Chairperson, you've touched on the issue of the capex. It is just that I wasn't sure because there were a lot of issues with regards to that capex and the design, and Martin seems to recall all of that. And because it also had an impact of raising the rivals cost. In other words, the cost, the entry barriers in terms of others entering the market by gaining access to that infrastructure that was part of this project. So it increased that design, and whether that was prudent to do, because it's something that ought to have been considered at the time of the conception of the project. It's not necessarily about the scope of the project. It was about changing the project itself, the design, such that this design made it difficult for interconnection and therefore also raised the rivals cost. And the question is whether it was an efficient way of spending additional capex for that reason. And that, for me, is valid enough to have been part of the assessment, and whether that capex was indeed prudent or not. So that is the part that I was asking about, Chair. Thank you, Chairperson. But also, Chairperson, the timing of the implementation of the clawback, I think we may be advised later on, Chairperson, as we proceed on these things by legal services, whether there are limitations in taking action. If a matter has been going on for 8 years and it affects money, and whether we can still be in a position to take an action. So there are legal limitations in certain instances for a statutory body to take action or bringing action. Also for the purposes of the implementation of a clawback, taking away money when the construction was done some time ago, business went on, and then 8 years down the line or 10 years down the line, the regulator comes back and say, well, we think that you unduly benefited, and therefore we want to take back this money and to give it back. So there are some of those things that we need to take into consideration. And I'm hoping that when we analyze these things, those kind of principles must also be given due consideration, so that we don't get to ask about those things at this platform. They must be very clear in the consideration, in the legal analysis that is part of the document. Thank you, Chair.
Thank you. We note that. Having said that, just like us then to move to the recommendation. Just trying to find it. Oh, it is recommended that the PPS approves the final prudency assessment report on Sunrise Energy's Saldanha Bay LPG project, attached here to as Appendix A. The final prudence review report from the consultant is under Annexure 1. By show of hands, members. Thank you, Mrs. Banda. Thank you, Madam Maseti. Thank you, Advocate Tole. Madam Pungose. Thank you, Madam Pungose. So we conclude on item 6. We're moving on then to item 7. Second biannual report on transitioning of version 8 of the tariff methodology for petroleum pipeline facilities for noting. Madam Yobana.
Yes. Thanks. Thank you, Chair. Morning, members, colleagues, and the members of the public. The purpose of the submission is to request that the PPS notes the second biannual report on the transitioning of version 8 of the tariff methodology for petroleum pipelines facilities, which is attached here to its Annexure A. We would like to bring to the members' attention that the appropriate delegation matrix, upon consultation with the RSU, for this submission is section 1.13 of the Petroleum Pipelines delegation matrix of 26 October 2023, which allows the PPS to note the status, quarterly, and progress reports on information gathered on petroleum pipelines activities. The ER of March 2024 approved the transitioning of version 8 of the tariff methodology, subsequent to noting the report on the internal piloting of the same version 8 of the methodology for a period of 24 months from the date of the ER approval. This is the second biannual report, and the first one was noted by the PPS of October 2024. So far, we note that the transitioning of the methodology indicates in support or consistently with the results of the piloting that the newly revised tariff methodology continues to yield relatively efficient tariffs compared to the tariffs that are determined using the previous version 7. However, we have identified some key challenges which can be considered, and these include the implications of determining an efficiency adjustment factor through volume rules for a monopoly licensee. And on that aspect, there was a paper noted during the review period by the PPS. Also, we have challenges in terms of accessing volumes data, including the volume reports of the pipelines facilities that are for own distribution, as well as the pipelines from emerging or African markets, or the markets from the economies that have similar market conditions to the South African petroleum pipelines industry. There's also a need to determine an appropriate efficiency indicator for Transnet pipelines in addition to the current capacity versus volumes indicator. So we anticipate that the ongoing transitioning exercise, coupled with the guidance of the PPS, will address the challenges and formulate an appropriate way forward. And in line with this, it's worth noting that the PPS of January 2025, when considering the tariff application by Transnet Pipelines, recommended that the team considers the cost versus volumes analysis for further measure of efficiency, and this will be undertaken during the 2025-26 financial year as a separate project, but it will also fit into the reports on the transitioning of the tariff methodology that will also be produced to the PPS over the upcoming financial year. We therefore recommend that the PPS notes the second biannual report on the transitioning of version 8 of the tariff methodology for petroleum pipelines facilities attached here to as Annexure A. Thank you, Chair.
Thank you, Madam Yogwane. Members, any questions, comments, or guidance? By show of hands, please. I don't see any hands. By show of hands, members, if you are you note this report, which is the second biannual report on the transitioning of version 8 of the tariff methodology for petroleum pipeline facilities, which is attached as Annex A by show of hands, members. Thank you, Mr. Sibanda. Thank you, Madam Maseti, Madam Pungose, Advocate Tole seems to have disappeared. Oh, he's here. Sorry. Thanks, Advocate Tole. This then concludes the item 7, which is the noting of this second biannual report on the transition of version 8 of the tariff methodology for petroleum pipeline facilities. Taking us to item 8, which is the annual report on the implementation of the efficiency adjustment factor and volume rules element of the tariff methodology for petroleum storage and loading facilities version 5.
Thanks, Chair. I'll introduce the report again on behalf of Ms. Sibage, who's on leave. The purpose of the submission is to request that the PPS notes the annual report on the implementation of the efficiency adjustment factor and volume rules element of the tariff methodology for storage and loading facilities version 5. And similarly to item 7, the appropriate delegation metrics for this submission is also section 1.13 of the pipelines delegation metrics of 26 October 2023. The report aims to provide update to the PPS on the progress made since the full implementation of the tariff methodology, and it focuses on 2 aspects, namely the update on licenses progress in achieving their set volume targets, and an overview of all the applications processed during this financial year, which included the efficiency adjustment factor through volume rules. In the previous report that was noted by the PPS meeting of October 2024, it was reported that NESA set volume targets for 7 licenses, which are highlighted on paragraph 5.5. And out of these 7 licenses, only 2 met the volume targets that were set by NESA. As a result, the remaining 5 who did not meet the targets are ineligible for revenue clawback. And in order for the licenses to qualify for the revenue clawback, they need to achieve the target volume set, and a new efficiency benchmarking will be conducted to determine their efficiency levels. Further, paragraph 5.17 to 5.20 provide a practical example of the revenue clawback for a licensee that did not meet the volume target. And we also provide a report on the tariff applications that were considered by the PPS during the 2024-25 financial year that were used to assess the impact of the efficiency adjustment factor through volume rules. And the results are shown on paragraphs 5.21 to 5.45 of the cover submission. Finally, the suboptimal performance of the licenses, the 5 that did not meet the volume targets that were set by NESA, prompted a process of engagements in order to better understand the challenges that they are facing, which may be hindering the efficient operation of their licensed facilities. And out of the 2 engagements that were initiated, we received feedback from 1 licensee, and because of the confidentiality nature of the response, we'll just summarize the general basis of their submission, where they basically highlighted that the key challenges that they faced for their 2 facilities located in Bloemfontein and Tzaneen include the focus on the decline in sales, the impact of the market competition, as well as the tariff increases. We know that we only received this feedback a few days before this meeting, and therefore the details on the engagement will be provided in the next installment of the report, hopefully with further engagements with the other licenses that did not meet targets. Against this backdrop, it is therefore recommended that the PPS notes the annual report on the implementation of the efficiency adjustment factor and the volume rules element of the tariff methodology for petroleum storage and loading facilities version 5, attached here to as Annexure A. Thank you, Chair.
Thank you, Madam Yogana. Members will recall that it's not very long since the introduction of the efficiency adjustment factor and volume rules in our tariff methodology, which is a progressive move. And I hope that also in this process we'll be learning and refining as we move along without causing uncertainty. Any questions, comments, or guidance, members? Madam Pungose, over to you, ma'am.
Thank you, Chairperson. I just want to get feedback. I did hear about the feedback from the one licensee regarding the impact of these efficiency adjustment factor and volume rules, that it led to declining sales, etc. But I want to know, because as per clause 5.2, there were various workshops held, industry workshops with various stakeholders. So how were these received? I mean, are the stakeholders supportive of these new rules, as well as the efficiency adjustment factor as introduced? That's just all from my side. Thank you, Chairperson.
Thank you very much, Madam Pungose. Over to Mr. Sibanda.
Thank you, Chair. Chair, I think the report paints a very good and welcome picture in terms of the implementation of the volume rules and efficiency adjustment factor. However, what I was looking for also perhaps challenges or lessons learned so far. I recall at some point when dealing with applications, there will be instances, for instance, where we could not find comparable peers and other challenges as well. So I thought it might be useful just to perhaps have a section that talks to challenges or lessons learned. This could be done in future, Chair, but I think it might be just a useful thing to highlight whatever challenges there are. But so far it seems these are being implemented well. Thank you, Chair.
Thank you very much, Mr. Sibanda. Over to you, Madam Maseti.
Chairperson, I'm covered by my colleagues, but I thought that I should express my appreciation to the team for the work that they've done, in this area since we've started this work. I think it's more than 4 years ago or so, but they've been really, progressing in this area very well. The only thing that I just wanted to check is the reason why whether they've tested the reason or concern by the licensees who are saying that these rules are affecting their sales, in the sense that the sales are declining. For me, it doesn't sound like it is something that is caused by the mere fact that the regulator is doing what it has to do, which is to ensure that there is efficiencies. How does that affect the sales, if I may just find out, and whether the team has taken up that concern and engaged the licenses as to how, and also the team to do its independent verification of whether that indeed is the case. Thanks, Chair.
Thank you very much, Madam Massetti. May you please respond, Madam Yogan and the team?
Thank you, Chair. Maybe I'll just start from the last question and go up with Ms. Massetti's question on the reasons for the declining volumes. As a team, we've sort of started to just group the efficiency concerns and the key concern of declining volumes into an internal PPT project that we've termed the Volumes Project, where we sort of study all the concerns and the trends happening in the industry. And what we've been able to pick up is that most of the licensees, including the pipelines, are struggling to go back to the pre-COVID 19 volumes. However, there is a slight upward trend in terms of the volumes improving. And so the claims of the efficiency adjustment factor resulting in declining volumes, we've not been able to substantiate, but we aim to further consult the stakeholders on a one-on-one basis, and also to monitor their applications. But one thing we've noted amongst the ones that have not been able to meet their targets, some of them have not even read the decisions on the previous tariff applications, which express the concerns with the performance of volumes. And we've also started a process of engaging the said applicants or licenses on these volume issues. Even the market projections that we receive from the BER do provide positive projections on petroleum fuel products for the next maybe 3 years in line, even though we have an up and down trend in terms of the performance of the GDP in the country. And also to align this with Mr. Spander's question on the challenges or the lessons learned, I think we have also appreciated that we may have to add into our advocacy plans more sections on the importance of the tariff methodologies, the guidelines, and just the legislative framework behind the regulation of tariffs, and also the importance of the representatives of the licensees to take note of the decisions of the energy regulator. A challenge that we have expressed is that we do not have key collaborations with some of the SADC or BRICS or African countries in terms of sharing information, because in the markets that we need that may have similar market conditions with us, the volumes data is considered confidential, and therefore we may need to start facilitating such collaborative initiatives through the Office of the International Relations just to access more data. But we've also have indicated that we need to amend our criteria for identifying peers to also look further into the factors that may affect the performance of licenses. For example, the locations of the licenses may affect how they perform in terms of volumes, whether they deal with the same product or not. And then on Ms. Mpungo's questions on whether the stakeholders support the efficiency adjustment factor through volume rules. When we started the consultations, we even had one-on-one consultations with some of the major licenses, and we received mixed sentiments in that they do appreciate the initiative by the energy regulator. However, they are concerned by the performance of the economy and also just the ever-changing conditions in terms of the geopolitics and the climate change that do affect their volumes or their performance. And so they were just advocating for leniency when we try to make a decision on their efficiency levels. And the key concern for them was the money that they would lose through the clawback applications. Thank you, Chair. I think I've covered the questions.
Okay, no, thank you. I take it that you also note the meeting chat. Notes there where it says to consider also working to collaborate with RAR, and it is important that you deal with the claims and refute the claims because the efficiency could only drive tariffs down if people are not efficient and not necessarily say that they reduce volumes. They would reduce, they to be equivalent to the reduction of the volume in the sense that you are saying that the capacity is, you're not giving it the equivalent of a bigger capacity that is actually sitting idle and not being utilized. So please, I hope that in the next report, when you talk of the consultations with the licenses involved, you'll also talk to this issue to reflect on these claims and kind of clarify them for ease of understanding. Okay. I also note from Madam CEO to say collaboration and sharing of information can be done with SADC regulators regarding petroleum pipeline, subject to non-disclosure of confidential information. We note that. Please then do make those enhancements. And also from what Ms. Banda highlighted, the issue of challenges, lessons learned, because we need to keep an inventory of improved potential or prospective improvements, and then be able to then ensure that we improve, we enhance our regulatory framework accordingly. With that, members, I think just indicate if you are happy with the responses and taking all these comments, guidance, as well as questions and responses thereto into consideration. May we then please indicate if we do note the annual report on the implementation of the efficiency adjustment factor and volume rules element of the tariff methodology for petroleum storage and loading facilities version 5, which is attached as Annexure A by show of hands. Thank you, Madam Maseti, Mr. Sibanda, Madam Pungose, Advocate Tole. This then concludes item 8, which is the last item for the open meeting. I would like to take this opportunity to thank the members for all the comments, questions, and guidance provided, as well as management and staff for their responses. I also want to thank the members of the public that are following us through the various live streaming platforms, because by so doing, just merely doing that, it also helps us to try by all means to be efficient and effective in executing our duties.